Hello, and welcome to Hospice Insights, the Law and Beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. The rules, they are a-changing. CMS proposes a significant change to the 60-day repayment rule. So, Bryan, this felt like it came out of nowhere.
It did. Snuck up on us during the holidays. Those crafty folks at CMS proposing some rule changes, but it's got everybody's attention now. It's got our attention, and there's still some time to affect this. When it goes into a final rule is anybody's guess, but
there's a lot of hyper technical legal stuff that can be hard to follow along, and that's boring anyway. So that's sort of cut to the chase here in what is it that is being changed here that would change the daily lives of hospices?
Sure. And I think a lot of that has to do with compliance investigations and your planning for those. So under the current 60-day repayment rule, CMS was pretty clear that when you get information that maybe there's an overpayment, for example, somebody on your staff says, hey, I think there's a problem with an admission, or I think there's a problem with our document, or you do some internal auditing and maybe there's a problem with GIP admissions and you need a repayment to make a repayment to the government. CMS was pretty clear that you should have about 6 months to really investigate it, understand what the issue is, if it is an issue, quantify the amount of any repayment. And then once you've got the nature and quantity of the overpayment, which the rule calls the identification of the overpayment, you then have 60 days to actually cut the check to the government and satisfy your obligations. That time frame is thrown into a lot of uncertainty by this proposed rule, because what they've done is they've eliminated the language that relates to this reasonable diligence investigation. And so it is very unclear at this point whether that default 6-month opportunity to investigate something is going to exist, or is it going to be more measured more on a case-by-case basis. And maybe there's a prosecutor out there who would say, I think you could have finished this investigation in 2 weeks or 2 months, or who knows what. I think the issue is we don't know. And so how do you measure how much time you should take to investigate before you're crossing a line? That line will no longer exist under the new proposal. And so it just leads to more uncertainty.
Well, and the risk that we're talking about is if you retain an overpayment, that's a reverse false claim. And so the concern is if there's no shared understanding of how long, what are my parameters for doing this reasonable inquiry and repaying, you got this hot potato and it's like, do I have to start, is a clock ticking? And like you said, in 2 weeks, you should have done this in 2 weeks. You didn't repay within 2 weeks or something. Do you have potential false claim liability because you're retaining, quote, a known overpayment? And I think what's interesting about this is the background on this proposed change really stems from litigation that Medicare Advantage plans have had against CMS. And so it's not really in the provider context, but Medicare Advantage plans have a repayment rule. We have a repayment rule. Other people have repayment rules. And so the thought was, and maybe I'll have you explain the little bit of color there and why CMS maybe feels like they have to make a change so their rule isn't invalidated, perhaps.
Yeah, of course, and that kind of brings in the fact that there's a good thing for providers in this change. I've just described the uncertainty that results from it, but there was truly a problem that CMS needed to fix, because those court cases identified or found that the current rule lowers the government's burden to win a false claims case to a standard called negligence. So in some circumstances under the current rule, a provider could be found liable under the False Claims Act for mere negligent conduct. And that is contrary to how almost every court, I think the prevailing law nationwide about the standard for the False Claims Act, it is not an act that goes after mistakes, honest mistakes, and negligence. It's really geared toward the more knowing kind of violation of the law. And the current rule lowered that standard. That needed to be fixed, and they are fixing it by just referring to the False Claims Act knowing standard, which makes it more difficult for the government to prove its case. What I think the problem with the proposed rule as it currently stands is, in addition to fixing that burden of proof issue, they got rid of the whole time frame around this investigation, which I don't think they needed to do. And I think to the extent people can provide comments, I think that's kind of an area of comment to provide about this, is retain the certainty so there can be, as you said, Meg, that shared understanding of how people can comply with the law. And you can do that while resetting the standard to the appropriate level so that you're not sweeping up honest mistakes into a False Claims Act lawsuit.
And I think that there's going to be a lot of comments on this. And as you mentioned in the beginning, who knows when this will go to final rule? Like when the 60-day repayment rule first came out, I can't remember how many years it was from proposed to final. So, when we're dealing with the wage index, right, that we always know sort of like clockwork, when that's around, when that's going to be released, when it's going to be finalized, when it goes into effect. And so I expect there is going to be a lot of feedback to CMS on this, that they're going to obviously fully vet internally and I'm sure take into account. And so also just visually, and we're going to link to the proposed rule, this is a very small part in the rule. And the discussion, the commentary in the rule about why they're doing it, I mean, they reference this case, but there's not a lot else said because, as you said, they did make more changes than maybe they need to accomplish the challenge of the court cases that have said, hey, you shouldn't create a negligence standard for the False Claim Act. So I think it should be really interesting. And I think probably every national association and many others are going to be commenting on this, rightfully so, because this is important. Because I think every time you and I do training on the 60-day repayment rule, we say, oh, it's sort of a misnomer that you have 60 days because that's after you quantify the overpayment, you have 60 days to return it. But actually now the way it's written, it's like more like you have 60 days sort of at the most to do this. And I think it just really cuts against everything CMS, which I think was very reasonable, of saying it takes a lot of time to do many of these investigations because they're complex. And, probably a third of the work that we do in our practice group is internal investigations and guiding people through these kinds of analyses, which oftentimes have a large legal component. Are there legal arguments? Are there clinical arguments? There's a lot to do and a lot of thought that goes into this to figure out, do you actually have an overpayment? And I think that CMS was very practical in the original rule of understanding, like, as a provider, you have a lot on your plate, and these things may involve a lot of different departments within your organization, and a winnowing down and really, sifting through what may be alleged versus what may be simply, I guess, what's actually validated. Because when you get a complaint, as you said, Bryan, what may be part of the complaint as you talk to more people actually that doesn't vet out that way. And I think that that's the purpose of doing an investigation, right? Like, you don't just take the complaint for everything and that is true. You have to actually go through the effort of vetting that complaint and understanding what the truth really is.
Yeah, and the complexity of those investigations, which you and I have done, Meg, and when we get first call from a client about here's the problem, that rarely is what the problem ends up being exactly.
Absolutely.
There is a ton of analysis and investigation, including statistical exercises, and CMS acknowledges you may need a statistician to get involved there. I think the cases that generated this change did not implicate those kinds of complex investigations. It was much more of a, on its face, you can tell it's an overpayment and therefore pay it back. And I think that's why the language of the proposed rule is, it affects a more broad change than it needs to, because they weren't mindful of the complexities of these investigations in Part A Medicare hospice claims that exist. So hopefully CMS will understand that it needs to preserve some certainty just to make sure that there's this shared understanding. Hospices want to comply. You just got to give them the tools so that they can comply.
Well, great job in distilling something that's very, I think, complex. Because when we were analyzing this internally, as you know, one of my favorite words is synthesize or distill down, because I think there's things that have been written out there, but like you're still trying to figure out so what's the real impact of that? And I think that's the magic. And that's obviously what we always strive to do is how is this actually going to impact how I run my business and what obligations I have. So thanks for doing a great job on that, Bryan.
Yeah. You're very welcome.
You always have those litigators always have those fancy oratory skills that just make you always sound so smart, Bryan.
I've been rehearsing for this podcast for days and days.
I
just
know.
to get it just right.
I know. So as I mentioned, we're going to have the proposed rule for those that are interested in the liner notes, so you can check it out yourself. But I really appreciate everyone listening, and thanks again for your insight, Bryan.
Thank you, Meg.
Well, that's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, may the wind be at your back.